Hello, my name is Alejandro Garro, and I'm from Columbia University Law School, and I will be talking to you today about Article 79 of the CSG, that is to say, of the Vienna Sales Convention. As you probably have heard, when you reach the time of Article 79, is because you already had gone through very basic aspects of the convention. One of them is that if a party does not perform, he has to pay damages in addition to any other remedy that the convention may give them. Now, Article 79 specifically addresses the circumstances in which a party is not liable for damages for failing to perform his obligations. Now, most legal systems deal, of all kinds, common law and civil law, deal with this problem of the law of excuse. But the problem is that they deal under different labels and different names and under different conditions and requirements. All of them, however, had something to do with the question of some kind of an obstacle that impedes or prevents the performance of the obligation for which a party who invokes it has a good excuse. The names could be force majeure, such as Articles 1147, 1148 of the French Civil Code, impossibility of frustration of contracts with other requirements under the common law doctrines, and then the Uniform Commercial Code came in with Section 2615 with this notion of impracticability. Now, of course, civil law countries have their own terminology. The French, even though in private law they never recognized this excuse, they did in public law through a case law of the Conseil d'État going as far back as 1916. This doctrine is imprévision, which actually deals with this problem of the changes of circumstances that make the contract much more harsh to perform than otherwise would be. And the Germans had to invent their own theory, the idea that if the assumptions that were at the basis of the contract were to collapse or were not to exist, then in that case the contract can be either terminated or adjusted or adapted. Under the doctrine of Wegfall der Geschäftsgrundlage, the collapse of the foundations of the contract, the Germans have developed this other theory. Now, Article 79 deals with all of these problems and more. But the questions on which Article 79 focuses are basically, first, the issue of what actually triggers an excuse, meaning how tough an obstacle must be to prevent performance and for a party to justifiably rely on that impediment not to perform. The second question is, what are the consequences? Is a party, of course, released of these obligations, but can he request for termination? What about adaptation? What about enforceability of some aspects of the contract that can still be carried out despite the impossibility to perform other aspects? Well, these are issues that Article 79 focuses on. Now, of course, Article 79, as many other articles of the Convention, is a result of a compromise. A compromise between positions that range between those who thought that the contract had to be performed no matter what, because otherwise if you start making exceptions, everybody would actually try to get out of the contract very easily. So this doctrine of strict liability of the contract, which can be probably labeled as a contract, always a contract, and unless you cannot perform, and you actually prove that it's impossible, you have to perform. That was one extreme position that had to be confronted with that of those legal systems which, inspired by canon law, were much in favor of this idea that if, after the conclusion of the contract, circumstances were to change in a drastic manner, turning the obligations and extremely harsh, well, that there is a threshold of sacrifice beyond which it is inappropriate or even against good faith to require the obligor, the debtor, to perform. And that is the doctrine which, under the various names, have been known as the hardship doctrine. Now, 79 tries to accommodate and analyze all these aspects of excuses leading to the exoneration of the party who invokes that excuse. Now, the terminology of 79, however, is different. Article 79 doesn't include the word hardship, nor basic assumptions, the consequences of which the parties could not have foreseen, or anything of that nature. It talks about, it has its own terminology, its own syntaxes, its own approach to this problem. But this problem, actually, of 79, actually addresses three functional, very important questions. First and foremost, what triggers an excuse? What type of problem there must be? And the word they use is impediment. Rather than difficulty or other types of language they use, it must be an impediment. What an impediment is unclear, but you would have to analyze it through different aspects of the convention, which I'm going to address in a minute. The second question is, assuming that there is an impediment, who is excused, and for what type? Well, many legal doctrines, domestic legal doctrines, only excuse the seller, which admittedly is probably the more practical issue that is going to come up. Not so much the buyer who's unable to pay, for which he is rarely to find any excuse, but yes, the seller who is unable to deliver. Now, the Article 79, unlike the UCC Section 2615, excuses any of the parties, be seller or be buyer, and for any of its obligations, meaning, unlike, again, UCC Section 2615, it doesn't deal only with the obligation to deliver or the obligation to deliver in time. It deals with any of its obligations. Now, what are the remedial consequences if a valid excuse were to be found? 79, again, has its own system, and it says that it only releases the obligor, that is to say the debtor or the party who is to perform, from paying damages. Now, of course, this is somehow puzzling because on the one hand, you have a very generous acceptance of the doctrine of excuse. Any party can find an excuse, conceivably, for the failure to perform any obligation. But on the other hand, there is a narrow conception of the impediment, because it has to be an impediment, first, that is beyond the control of the party who invokes it. Secondly, that he could not have reasonably have taken that impediment into account at the time the contract was concluded. And thirdly, even if he proves there was an impediment beyond his control that he could not have reasonably taken into account, once that unforeseeable impediment beyond his control materializes, he also has to prove that he could not reasonably have avoided or overcome the consequences of that impediment. Now, there's one thing clear under 79, which emerges from its text, saying if he proves that the failure to perform was due to an impediment, and that is the burden of proof. It is the party who is invoking the impediment, the one who has to prove actually that those requirements of 79 have been met. Other than that, Article 79 calls for a very careful and fact-intensive analysis. First of all, what does it mean that the impediment has to be beyond the control of the party who invokes it? Well, that actually is quite a tough question, because it calls for an inquiry whether the party who invokes the impediment took reasonable precautions to avoid it. Now, what is reasonable? At some cost, anybody can actually protect himself or herself against the risk of a contract that may go wrong for one reason or the other. But the question here is whether or not the efforts that are called for to protect himself against that risk are actually reasonable or practicable. Let's put a case, for instance, of fire. Anybody can probably, or most cases, prevent fire if you have, let's say, a round-the-clock guard taking care of the premises. But what if the contract makes that not worth? Is it reasonable to demand from the obligor such amount of expenditure? That is a fact inquiry that Article 79 calls for. The second one is that even if there is an impediment that is beyond the control of the party, and that he or she could not have done much to prevent it, the question is whether or not that party could reasonably have expected to take that impediment into account at the time the contract was concluded. Now, let's assume, for instance, that a seller ships goods through a zone in which hostilities occur, and the seller's ship, as a consequence of hostilities, is seized and the cargo is lost. Now, the factual inquiry of this question, whether or not he could have reasonably have expected that risk to emerge, is whether or not it was reasonable for the obligor to take into account perhaps not only that there were hostilities and that therefore that the loss of the cargo was likely, but also whether the loss of the cargo was likely in itself. So it really, the slippery question of foreseeability calls into question, first, what is the risk that the debtor, obligor, or party who invokes the impediment should have taken into account at the time of the conclusion of the contract? And on this matter, I'm sure there is more than one opinion. And the second is how reasonable is to expect the obligor, the party who invokes it, to actually have devoted the time, reflection, and resources, money, that requires to have taken that impediment into account. And again, if the example of the seizure of the goods comes into play, then you have to think yourself, well, according to the value of the goods, according to the circumstances of the case, was it reasonable to expect that the cargo would be lost because it could have been seized by some enemy forces or something of that kind? Now, that again is a second type of factual inquiry and would lead us to our third inquiry. Assuming that there was an impediment, assuming that it was beyond the control of the party, and assuming that he or she could not have reasonably taken that impediment into account, the next question is, could he, meaning the party who invokes it, have avoided or overcome the impediment or its consequences? That calls again for another factual inquiry. Let's assume that the buyer, right, who contends that even though the risk could not have been foreseen, even though it was beyond the control of the seller, even though it was something that it was impossible to actually to have predicted, that the seller could nevertheless, if the cargo is lost, have taken the goods from somewhere else and performed the contract in any event. Let's go back to the case of the contract of the cargo that is being lost because it is seized, the goods are seized as a result of the hostilities. Let's assume those are fungible goods, sugar, oil, whatever, not a unique machinery, let's suppose. Now, let's suppose also that that cargo that is being lost is worth, let's suppose, $1 million. Question: if the seller is bound to deliver sugar, oil, or whatever, and that sugar or oil is seized by enemy forces, should we expect the seller to go somewhere else and buy that sugar and oil and deliver it to the buyer? Well, of course, that calls into question for many aspects. Let's suppose it's oil that was supposed to be delivered from some Arab country to the buyer, and there is some embargo in the Arab country. Question: could the seller have resorted to, let's say, the Rotterdam spot market, where he could have bought the same kind of oil, but not for less than 1 million, but for 2 million or more? Question: could the seller have been expected to overcome or to actually avoid the consequences of the impediment by going somewhere else, buying the oil, even at a loss, and sell it or deliver it to the buyer? Now, again, this question calls into play many aspects of the transactions, one of which seems to me is whether or not it's reasonable for the seller to provide conforming substitution of the goods, even if that imposes a loss to him. Now, that depends what kind of a loss and what kind of damage would have avoided to the buyer. And it seems to me that most judges or arbitrators will look at the effect that the non-performance would have had on both parties, the cost that that would entail, and then somehow to come up with the idea whether or not it was reasonable for the seller to expect to have avoided the consequences. In the case that I've just mentioned of a contract whose performance is impeded because of this loss of the cargo, let's suppose the contract is a $10,000 contract, and the seller could have avoided or overcome that problem at a $100 cost, avoiding, therefore, say $5,000 loss to the buyer. Well, assuming that it is possible actually to count those figures, I think an arbitrator or a judge would no doubt impose on the seller the burden to go and get the goods somewhere else and deliver them to the buyer only at $100 loss in a $10,000 contract, which have avoided a $5,000 loss to the buyer. Now, this assumes, of course, that courts are in a position to actually inquire, verify that that is the value of the contract, that that's the losses that there were to ensue in case of a failure to perform, which something is not very clear, and that's why in many countries that the doctrine of impossibility is limited to absolute impossibility, because they assume that courts are very badly prepared to make these kinds of factual verifications, and it's better just to simply not to intervene, let the losses lie where they fall, and encourage or induce the parties to expressly allocate risk whenever they enter into account into the contract. This is not the position of 79, because 79 requires under this three-pronged test, if you meet them, it would make possible for the seller to actually find a valid excuse. I've spoken about the first paragraph of Article 79, and I should address the second paragraph of Article 79, which I expect you have with you in your presence. But I will read it to you just as an introduction for you to understand what role was meant to play in the second paragraph. It says, if the party's failure is due to the failure by a third person whom he has engaged to perform the whole or a part of the contract, that party is exempt from liability only if, A, he is exempt under the preceding paragraph, and B, the person whom he has so engaged would be so exempt if the provisions of that paragraph were applied to him. This provision, which actually foresees a situation where a party, let's say the seller, engages a third party to perform the contract, actually has been misunderstood by many people who just read it. There's no question by reading the legislative history of these paragraphs 2 of Article 79 that it was meant to aggravate the seller's burden to get out of the contract in case of impossibility. And that follows the idea that if the seller were to delegate performance on someone else, that seller should be deemed to have control of that third person, and therefore whatever occurs to that third person, it should be imputed to the seller. Of course, 79.2 makes it possible for the seller to be exempted. What is important to understand is which are the requirements to be met in order for that seller to be exempted. Now, the Supreme Court of Germany, the Bundesgerichtshof, has rendered decisions making very clear that in most cases, the seller who has subcontracted the performance of a contract will probably be found liable under the contract, and if not, and he invokes impossibility, he probably would be, his impossibility to perform will be determined under the first paragraph 79. Yet, I think it's important to make the effort to use second paragraph 79 whenever there is a situation in which the seller relies on a third person. Granted, it's not clear under 79.2 what type of third person is being covered. What the convention talks about is whoever that third person is was engaged to perform the whole or part of the contract. So it may well be referring at someone who delegates the performance of an important part of the contract. Let's put the case, for example, of a Canadian buyer who agrees to purchase a machine from a Hungarian seller, who in turn engages or hires a subcontractor, let's say a manufacturer of electrical equipment, in charge of producing the motor, who would actually make that machine work. Now, let's suppose that just before performance is due, the motor is lost because the plant where this subcontractor manufactures the motor explodes, and the Hungarian seller, therefore, is unable to deliver the machine. Well, the question is, can the Hungarian seller find an excuse due to the explosion of the motor to deliver the machine? And the analysis is the following. In the first place, that seller would have to show, under paragraph 2 of 79, that the explosion of the subcontractor's plant was an impediment under Article 79.1, which actually applied to that same subcontractor. And therefore, if that first prong is being met, you would be ready then to go to the second prong, which is subsection B of paragraph 2 of Article 79, meaning it's not enough to prove that the impossibility qualifies as a real impossibility under the first paragraph. You also have to prove, the Hungarian seller has to prove, that he himself is also exempt to perform. Why? Because he could readily not obtain a substitute performance of the motor from somewhere else, because he could not reasonably have foreseen that that explosion could have occurred, etc., etc. But therefore, this is the idea under the second paragraph of Article 79, which should be very, very clear to all of you then, that you have to comply with this two-step requirement. Paragraph 3 and 4 of Article 79, where I'm moving now, deals with issues that are not so much controversial. The third paragraph deals with the situation of what is called temporary impossibility. And that means, and I'm reading from third paragraph, The exemption provided by this article has effect for the period during which the impediment exists. Now, that means that you can find an excuse if you prove it under 79.1, but only as long as that impediment exists. As long as that problem disappears, you are still bound to perform. One of the questions that 79.3 does not resolve is what if that impediment prolongs itself for too long time. And the question of whether that temporary impossibility may turn into a permanent impossibility. Finding an excuse under 79.1 is left open by the convention. The question to raise, therefore, is what if the seller cannot perform and the impediment lasts for 10 months or longer? After 10 months of suspension of the performance, would this buyer be still bound to take delivery and pay? Depends on the circumstances, and that is a reasonable answer under that paragraph. It may well be that after 10 months it doesn't make sense to perform, that a fundamental breach has occurred, and that therefore the buyer could very well file suit and avoid the contract on the ground of impossibility under 79.1. The other issue is the notice requirement of the fourth paragraph of Article 79. And that fourth paragraph provides that the party who claims impossibility or claim in that impediment must give notice to the other within a reasonable time after the party seeking the exemption knew or should have known of the impediment. Now, the sanction for the failure of not giving notice is damages, and that is very clearly spelled out in the fourth paragraph of 79, which calls for no other explanation than the one just gave you. The final paragraph is a little bit awkward and somehow puzzling. It provides that the only remedy of which the only remedy that the party is exempted to is damages. Let me read it to you, the fifth paragraph. It says, nothing in this article prevents either party from exercising any right other than to claim damages under this convention. Now, this imposes some difficulties because one wonders, how can a person who successfully claims an exception be said to be rationally required to perform in kind? Of course, that if he could have been, he was in a position to provide substitute performance, then he rarely could have succeeded in invoking impossibility under 79.1. What this article is meant to say is that out of the panoply of remedies open to the other party, the buyer in this case, it may be convenient for the buyer to ask something short of payment of damages if some part of the performance can be rescued and some part of the contract can be performed. For instance, let's suppose that there is impossibility to perform just a part of the contract, which is actually a substantial part of the contract. Now, the non-breaching party may seek avoidance of the contract because there was a fundamental breach. Let's say most of the delivery was impeded. Yet, he has Article 50, which refers to a reduction in price, can be invoked, and the buyer may still require performance and say, but I want the price to be reduced in proportion to the value of the goods left. And I think that is a possibility obviously open under the first paragraph of Article 79. There is also the possibility that even if that there is a possibility that also that the agreed party may salvage some part of the performance, may seek avoidance, but nevertheless may also seek restitution of those parts of the contract that are can still be performed. So these are possibilities under 79.5, and that leads me to the point, probably the final point that I want to address under this article. A problem that is not specifically addressed, but already has been the subject of different decisions, and of course the disparity in legal scholarship on this problem. And that is the question whether or not the notion of impediment under the first paragraph of Article 79 does include the possibility of finding an excuse in a situation of extreme economic hardship. Now, this calls into question whether or not increased costs of a performance can be ever an excuse for the seller of goods to actually find an excuse under the first paragraph of Article 79. Should there be any excuse on the grounds of economic hardship? Well, one may well say, as the French Court of Cassation has been repeatedly saying in private law matters, that a contract was always a contract, and short of impossibility, there is no room for domestic rules on hardship. One may also say that, as the common law courts have said, also that once a contract has been concluded, the party can rarely find any type of excuse unless those requirements of impracticability or impossibility are being found. But if you look at the modern legislation, such as the new Dutch Civil Code of 1993, the UNIDROIT principles of 1994, you will find that the UNIDROIT principles, for instance, take a dichotomy approach, meaning on the one hand, they deal with the problem of impossibility or impediment under Section 717 of the UNIDROIT principles, and under other area of the UNIDROIT principles, Section or Article 6.1.1, they deal with the situation of hardship or economic hardship. Now, this dual approach calls for, as a remedy, the party's good faith incentive to renegotiate the contract and eventually to terminate it or to adapt it if that renegotiation were not to lead to any successful result. One important thing about 79 is that actually doesn't define impediment. So it is conceivable to find that economic hardship may be found as one possibility of an impediment, one aspect of an impediment leading to the successful excuse of the party who invokes it. Now, whether or not a factual scenario of economic hardship should be characterized as an impediment under 79 is certainly not an issue to be decided under domestic law. And this is a point made very clear by opinion number 7 of the Advisory Council of the CIG, who took the position that the notion of impediment does not exclude the possibility of economic hardship. And the idea was, of course, to try to avoid a big threat to uniformity by allowing domestic legal doctrines of hardship to proliferate and to be applied under Article 7.2 in accordance with the rules of private international law. Under this opinion of the Council, and under what I believe to be a consistent opinion under the Article 79, if there is a genuine case of hardship where all the requirements of Article 79.1 were to be met, in that case, the party who claims relief may actually claim relief, may be actually bound to perform to restitute and to any other of the remedies other than damages under Article 79. This is a possibility then that it should be considered very seriously. And it should be considered because even though the opinion does not spell it out in its words, the opinion does exclude the possibility of relying on domestic laws on hardship if a situation of a real economic hardship have been found. Whether or not the absorption of these hardship doctrines under Article 79 would lead to a uniform application of 79 remains yet to be seen. Why? Well, because the notion of impediment, as we have seen in the explanation given under the requirements of 79, is quite strict. And by actually absorbing the notion of hardship within the notion of impediment, it will be extremely difficult to find hardship under Article 79, paragraph 1 of the CIG. Actually, that's not a bad result, because no one meant under that provision of 79 to make it easier for the party who faces obstacles to be relieved of its obligation. And therefore, the Article 79.1 stands as a very serious obligation to perform unless very serious and genuine situations of hardship were to be found. Now, if that situation of hardship were to be found, what are the remedies available? Well, it seems to me that a proper arbitrator or a proper court may well incentivize the parties to renegotiate in good faith the terms of the contract, and if they fail to do so, may apply those remedies, flexible remedies, which are found to exist in Article 6.2.2 of the UNIDROIT principles, meaning termination of the contract as of the time the hardship is to be found with some kind of adaptation. It's true that common law courts are unlikely to order renegotiation or to even engage in any revision or adaptation of the contract as a remedy, yet it is a possibility, and the evolution of the CAG in the years to come will say or determine whether that would be possible. For this time being, and with this I will conclude, it is quite encouraging for the parties, and the first advice that should be given, that any party who enters into a long-term supply agreement not to rely merely in an interpretation of Article 79 of the CIG, but rather to engage in a well-drafted choice of law clause, probably providing for the application of CIG complemented by the unit law principles, which provides in a clear terms for a clear situation of a hardship. This seems to me the best advice one can give at this point in time, but also coupled with the fact that if a hardship were to arise, and if an impediment under 79 were to arise, the parties will definitely be facing an article which, well interpreted, may well lead to a fair settlement of the case. Thank you very much.